Hello. Hello, and thank you for joining us for this webinar entitled Young Lawyers and Data Privacy, GDPR, CCPA, and Beyond, Meaningful Contributions in a Fast-Evolving Space, part of the American Bar Association's Young Lawyers Division Litigation Committee's Litigation Week, co-sponsored by the Young Advocate Committee of the ABA section of litigation. We'll start by having each panel member give an introduction on their position, background, and line of work. Shannon, would you mind starting?
Sure. I'm Shannon Yavorski. I'm a partner in Venable's privacy and data security team. I'm an English and Irish solicitor and a California qualified attorney, and I advise on European and U.S. data protection and privacy matters for a wide variety of clients, from startups to Fortune 100 companies. I do privacy assessments, privacy policies, and advise on the implementation of privacy programs. I also advise on the privacy and data security aspects of M&A transactions and commercial agreements.
Great. And Matt?
Hi, I'm Matt Roders. I'm a discovery counsel for Molo Lampkin in our Chicago office, along with Ben here. My practice generally focuses on discovery-related issues and fact development, and that intersects with privacy both in terms of making sure we are doing things properly when we're producing documents, but also with the advent of GDPR and other similar regulations, potentially limiting what we're able to collect and get as part of discovery. So relatively recent addition into the privacy sphere, but I think it's certainly a bigger part of my practice now than I ever would have expected.
Thank you. And Rishi?
Hi, everyone. My name is Rishi Balakhan. I'm a partner at EY. I've been with EY for the last 8 years, but prior to joining EY, I worked both as outside counsel and in-house counsel for a number of different organizations, both in the UK and then in the US. Right now, my practice is primarily focused on discovery and information governance and really helping my clients, many of whom are large US multinational corporations, handle cross-border litigations and investigations, and helping legal departments think through how they can leverage technology to automate and drive efficiencies into their day-to-day processes. So very often have to think about privacy through the lens of a complex cross-border litigation, and also have to think about it through the lens of legal departments and where they should store data on an ongoing basis.
Thank you. And Jeffrey?
Jeffrey Saling, Senior Discovery Manager at Novartis Pharmaceuticals. I sit in the in-house litigation and legal innovation team. And what I'm doing is really overseeing the discovery practices for Novartis globally. We're in 152 countries, and how we can comply with the regulations both within the US and outside of the US when it comes to data privacy, working closely with the legal team and privacy team to make sure that our processes are appropriate given the countries where our data resides.
Great. Thank you, and welcome to all of you, and thank you for being here. I'm the moderator, Ben Woodring. I'm an associate attorney at Molo Lampkin and vice chair of the ABA Young Lawyers Division Litigation Committee. When putting together this event, one dimension we wanted to emphasize was the application to young or early career lawyers. The issues we're going to talk about today provide a rare opportunity for new lawyers to get in on the ground floor, as it were, and build skills in a new and exciting area. So many of you joining us today probably have at least a little knowledge of GDPR, perhaps, and maybe why it's important, but just in case, to initially set the stakes, just this month, the Information Commissioner's Office, the ICO, doled out record fines for data privacy infractions to Marriott and to British Airways, totaling almost £300 million. The recent introduction of the GDPR strengthened the ICO's powers and enabled these massive fines. There's also developments like the FTC's recent $5 billion fine against Facebook regarding privacy protections, which shows the gravity of the matter and the trend toward increased regulation and penalties. And with the unprecedented amount of data flowing globally, part of the phenomenon here also has to do with the public and its interests as it gradually becomes aware of how its data is used, stored, sold, or perhaps manipulated. So a good example of privacy and data issues being hashed out in the public forum today is this recent rise of FaceApp, an app that does an eerily good job at predicting what someone will look like in old age based on one's submitted picture. And recent concerns are that FaceApp, which is a Russian company, may be getting access to more than just the one submitted picture on one's phones, or that there's information sharing with the Russian government, or that the data on facial lineaments might line up with unlocking phones. So all of these type of concerns intersect, as we'll see, with some of the logic behind the regulations that we'll be discussing today, and how law and business are adjusting to and preparing for such regulations. I'm not sure if anyone on the panel wanted to say anything on any of these topics more generally before we proceed to our conceptual overview.
Sure. I mean, I'll just echo that. I think this is a really interesting part of the legal sphere that is being pushed as much by social change and social awareness as it is by regulations and statutes. So I think, it's exciting to be a part of that social evolution as well.
Great, and just as an outline of what we'll be doing in this session, we'll be giving an overview of the GDPR as well as the CCPA and other similar laws, either currently extant or in the pipeline, and then we'll go in a little more detail through kind of a case example, and then we'll open it up for questions and parting thoughts at the end. I'll also give a brief reminder that nothing said here constitutes legal advice, and that the panelists are doing this on their own time, and what they say does not necessarily reflect the opinion or position of their employer. So to kick things off, we'll have Shannon giving an overview of the GDPR. Shannon?
Great, thanks so much. So the GDPR replaced the EU Data Protection Directive and became effective in May of last year. The preceding legislation, the Data Protection Directive, meant that there were multiple laws throughout Europe because a directive in Europe has to be implemented into national law. And the GDPR was introduced primarily to harmonize the law across Europe. And the principles that are under the Data Protection Directive are very similar to those that were in the preceding law. So transparency, the rights of data subjects, accountability, DPOs, security, supervisory authority, election, and international data transfer. And I'm going to talk about some of the core concepts and then hand over to Matt to talk about cross-border data transfer. So I think a key thing to mention about the GDPR, and something that's somewhat misunderstood, is the territorial scope. So the GDPR applies to establishments, so companies that have an office, agency, or branch in Europe, so boots on the ground in Europe. But it also applies to organizations that do not have boots on the ground in Europe if the organization is offering goods or services to people within Europe. So you can be headquartered in the US, but the extent to which you are reaching out to people in Europe in order to offer them goods or services, that company within the US may be caught by the GDPR. And as was previously mentioned by Ben, I think one of the main reasons the GDPR has garnered so much attention, and far more attention than the Data Protection Directive, is because of the blockbuster fines that are associated with it. So there are really tough sanctions for non-compliance. 4%, that can be up to 4% of annual worldwide turnover, or 20 million euros, whichever is higher. And one of the issues there is that the 4% of annual worldwide turnover is not based solely on the company that infringed the law. It's based on the revenue of the entire group of companies. So you can imagine what that means for really large multinational organizations. Core concepts under the GDPR, and I wanted to talk about this a little bit because there are some terms of art here. Personal data for the purposes of the GDPR means anyone who can be identified directly or indirectly by a reference to an identifier or including an identification number. So for the first time, it's pretty clear that things like IP addresses and cookie identifiers our personal data just as much as a name, mailing address, or email address are considered personal data. There are other terms of art that I think are worth mentioning because they're thrown around, and I think there's not a deep understanding of them. So the GDPR has two different concepts of a data controller, which is the entity that determines the purposes and means of data processing, and a data processor, which is the entity that processes data on behalf of a data controller. And if you think about a great example of a data processor is like a cloud service. They're not doing anything to the data. They're merely what we think about as a dumb pipe. So important to note the differences between data controllers and data processors because the obligations placed on either a controller or a processor are somewhat different. There are core data protection principles under the GDPR, so lawfulness, fairness, and transparency. Purpose limitation, so data can only be collected for specified, explicit, and legitimate purposes. Data minimization, so personal data processing must be adequate, relevant, and limited to what is necessary for the purposes for which the data is being processed. Accuracy, data has to be kept accurate. Storage limitation, so data can only be stored for as long as is necessary. And accountability, this is a really core concept under the GDPR. Data controllers are responsible for demonstrating compliance with the principles under the GDPR. The GDPR also introduces a number of rights for data subjects, and data subject is another sort of term of art, and it really means anyone whose personal data is being processed by an organization caught by the GDPR. So data subjects are entitled to transparent information in relation to how their data is being processed. They're allowed a right of access, so the organization has to tell them what data is held about them. The right to rectification, so to correct data that's held about them by an organization. The well-known right to be forgotten, so for you to ask an organization to delete the data that it holds about you. The right to restrict processing, the right to data portability, so to port your data over to another data controller, and a right to object to data processing. Going back to the right to transparency, organizations have to disclose certain specific elements under the GDPR. They have to disclose the lawful basis for processing, and this is another term of art under the GDPR. They have to disclose the rights, individual rights, so right to correct, erase, restrict processing of personal data, right to withdraw consent or lodge a complaint with the supervisory authority, and logic if they carry out automated decision making, they have to provide details in relation to that automated decision making. So to pick up on the lawful basis of processing, this is another term of art under the GDPR. And it's really core to European data protection, and this concept doesn't really exist in this way currently under US law. And it's really that before you do anything to personal data in Europe, you have to establish a lawful basis of processing. So there are 6 different lawful bases of processing that are outlined in the GDPR. So you can process personal data if you have the consent of the data subject. And the other lawful bases of processing that are commonly used are contract performance, so where your personal data needs to be processed in order for the data controller to perform a contract to which the data subject is party. So this is, for example, when you send your personal information for a hotel to book a room for you, they need your name in order to reserve your room. So that is processing where it's necessary for the performance of a contract. Another lawful basis of processing is legitimate interest. So this is an alternate to consent as a basis for processing, and it's where the processing is necessary for the purpose of the legitimate interest pursued by a data controller, unless those interests are outweighed by the rights of the data subject. So to unpack that a little bit, legitimate interest, the GDPR provides a little more detail on it. Examples are where the processing takes place for fraud prevention, transfers within a group of affiliated companies for internal administrative purposes, reporting criminal acts or threats to public security, and direct marketing purposes. And then I'm going to hit on two more principles, and then I'm going to hand over for Matt to talk about cross-border data transfer. So another thing that the GDPR talks about is data protection, data processing agreements. So Article 28 of the GDPR spells out that where you as a data controller engage a data processor, you have to enter into a contract with that data processor that outlines a number of different things. So for example, it has to include the purpose and nature of the processing. It has to set out data breach notification obligations, and the controllers and processors have designated tasks. So this is probably something that you've probably heard about in terms of companies executing data processing agreements with all of their vendors. And it's been a big task for organizations to accomplish. Another key change under the GDPR is the obligation on certain organizations to appoint a data protection officer. And this is where an organization, this obligation exists where an organization systematically monitors large groups of individuals or carries out large-scale processing of special categories of data. And these, the responsibilities on the data protection officer are to actively monitor compliance with the GDPR, provide advice on data protection impact assessments, and report to the highest level of management. And this is really interesting because in the FCC's recent fine on Facebook, more details of which came out very recently. One of the things that the FCC says is that Facebook has to have a sort of committee that has DPO-like responsibilities. So I thought that was a really interesting sort of parallel between how U.S. privacy law is evolving and the GDPR. So now I'm going to hand over to Matt to talk about another key feature of the GDPR, which is cross-border data transfer.
Thanks, Shannon. That was a great summary, and the only things I'm going to add are, this is building on 70 years of tradition in Europe, so this is sort of the byproduct of a lot of evolution related to data privacy, and the data protection directive that was replaced by the GDPR. All the case law that was in there still sort of applies, which means that in Europe, a lot of these concepts and a lot of these actions that are necessary are becoming pretty commonplace, but the U.S. lawyers are playing catch up because of the territorial scope and the limitations on cross-border transfer, which provide a fair amount of protection for EU residents that have data subject to the GDPR. There's a few limited ways in which data that resides in the EU or relates to EU residents can be transferred from that area to the United States or really anywhere in the world. The first is if that country has an adequacy decision. You would likely guess that the U.S. does not have one as a country, and that is absolutely true, but key economies such as Canada and Japan do. And we'll talk a little bit more about that later. Another way is through treaty, and the U.S. and the EU does have the EU-U.S. Data Privacy Shield that is entity specific, so it allows companies to sign up for it and become compliant, and then transfer data back and forth for the purposes of their business, but not necessarily transferring beyond that. Similarly, there's something called binding corporate rules, which require specific actions to be taken by a company and sort of extends the bubble of that EU presence to potentially U.S. affiliates or affiliates around the world, as long as they continue to comply with those binding corporate rules. Then, for dealing with subsidiaries or third parties, you can transfer data based on standard or model contract clauses. These are dictated by the member states' data protection authority. So in England, it would be the ICO, and there's others. So they're the ones that are issuing guidance on that. So it's somewhat member specific, is my understanding, and can have some variance on that. Beyond that, it comes down to derogations, which sounds just as pleasant as the word derogation. So There's some pretty limited exceptions to those sort of four methods, and they are the weapons of last resort, and it includes things like explicit consent, executing a contract on behalf of the data subject or the benefit of the data subject, the public interest, as well as establishing defenses and legal claims. So really, at the end of the day, the idea of GDPR is to allow free movement within that economic area, and then make sure that anywhere else that the data is going related to personal information for these data subjects that are protected by the GDPR, make sure that information is being treated with the same care that the EU is expecting of its own actors. So that's I think a very interesting point, and I think it is one of the issues that is driving more global awareness of data privacy and what that means in data protection, and certainly as the fines that are trickling in related to data breaches and other activity of the EU. I think that's just going to continue to grow.
Great, thanks very much. And now we're going to move to the more recent directly American context here in doing an overview of the CCPA.
Great, thanks so much. So the CCPA started in October of 2017 as a ballot initiative that was submitted to the California AG's office by consumer advocates, which included notably Alistair McTaggart, who is a wealthy real estate developer who talked to a Google engineer at a barbecue who told him the ways in which his data was being used, and that started off the whole chain reaction of events that led to the CCPA. So that was in October of 2017, and then in May of 2018, the advocates announced the initiative had obtained enough signatures to go to voters. And then I think at that point, the California AG's office entered into really intense negotiations with Alistair McTaggart's group. And in June of 2018, the California Consumer Privacy Act was the result of negotiations between the party, and it got the ballot initiative off the table. The issue is that the law was drafted in about a week's time, which has resulted in there are a number of internal inconsistencies within the law. There are Scrivener's errors, and there are still sentences that just kind of end. So it's been challenging for lawyers to provide advice on, because it's still sort of a moving target. And just to provide a little bit of context, not only are there additional technical amendments being proposed to the CCPA, but there are also several bills out there that are proposing to amend the law in pretty significant ways. Alongside that, you have the obligation within the CCPA for the California AG's office to issue regulations by July of next year, which is great, except the law comes into effect in January of next year. So that's a little bit of a challenging gap. There have been rumblings that the AG regulations will be issued in the fall of this year, so fingers crossed, but there are no promises. So the CCPA is probably the biggest change to U.S. privacy ever. And it is a broad law that covers businesses, any company that does business in California and meets any one or more of the following standards. So the company has an annual gross revenue over $25 million. And to be clear, there's currently no guidance as to whether that $25 million has to be in California only, or is the revenue of the entire group. So that remains outstanding. Collects or shares personal information annually from 50,000 consumers, households, or devices, or derives at least 50% of annual revenue from the sale of personal information. And I think it's really important to mention that the definition of personal information in the CCPA is very broad. It is the broadest definition of personal information in any privacy law of which I am aware. I thought the GDPR had the broadest definition of personal data ever, but the CCPA trumps it. It applies to its information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked with a consumer or a household. So a really, really broad definition there, which so broad in terms of its scope of application to companies and broad in terms of the data that it captures. There are some exceptions to the CCPA. The general exceptions include activities that are required to comply with federal, state, or local laws, to comply with civil, criminal, or regulatory investigations, to cooperate with law enforcement, exercise or defend legal claims. The CCPA also doesn't apply to information that's covered by HIPAA or the CMIA, and there are carve-outs for information covered by the GLBA, which is Gramm-Leach-Bliley Act, and the FCRA. It also doesn't apply to information that is personal information that is aggregate or de-identified, or conduct that takes place wholly outside of California. So what are the key changes? What are the main things that companies are going to have to do to comply with the CCPA? And I like to highlight here that some of the obligations are similar to those under the GDPR. So the CCPA creates new rights for individuals. It creates a right of access, a right of deletion, and additional rights of transparency. So in terms of the right of access, individuals can request that information held by a company about them is disclosed to the individuals, and the request has to be met by the company within 45 days. The disclosure must cover a 12-month period prior to the request, and consumers are limited to 2 requests per 12-month period. So that's the right of access. And then there's a right of deletion, so similar to the GDPR's right to be forgotten. And it generally applies to all personal information collected from the consumer. And the company also has to direct service providers to delete the personal information as well. There are a number of exceptions, so important to note that it's not an absolute right, and the company and organizations need to look at the exceptions before they delete the information. There's another right to opt out of sales, and the opt-out right is consumers have the right to opt out of the sale of their personal information. There's a very broad definition of sale, so it's any kind of selling, leasing, or sharing personal information. There are narrow exceptions to the opt-out right, and the organization has to wait 12 months before requesting that consumers reauthorize the sale of personal information. There's also a right of non-discrimination, and this is a general prohibition on organizations discriminating against consumers that exercise their CCPA rights. There are a number of website changes that are required, so organizations are going to have to put on their homepage a "Do Not Sell My Personal Information" button. They're going to have to change their privacy policies to disclose the categories of personal information they collect, the categories of personal information sold, the categories of personal information disclosed. And then they're going to have to be CCPA pages, so pages that allow consumers to opt out of sales and allow consumers to make requests for information. In terms of enforcement, the California AG is primarily responsible for enforcement. Businesses have a 30-day cure period after being notified of an infraction, and the AG can seek an injunction plus civil penalties of up to $2,500 per violation or $7,500 per intentional violation. And interestingly, there's no cap on the civil penalties. The California AG is incentivized to seek enforcement. Penalties and settlement proceeds are placed in the state funds. And the California AG urged an expanded right of action, but a recent bill was struck down that would have expanded the private right of action. As it currently stands, there is a private right of action, but it relates solely to data breach, and it really hinges on whether an organization has unreasonable security and that personal information has been subject to unauthorized access and exfiltration, theft, or disclosure of personal information. So I think the key takeaways here are, bear in mind that this law has a really sweeping coverage. It really applies broadly to a number of different organizations. The definition of personal information is very broad. There's a class action risk as a result of the private right of action. There are a number of new rules, and compliance with existing laws doesn't cover the requirements and scope of the CCPA. And there are obligations that will require business processes and business procedures to change. So that's a sort of high-level summary of the CCPA.
Great, thank you so much. Matt, did you want to add anything?
Yeah, I think, what's really interesting about the CCPA is that it's this extreme broad scope of the nature, including employees in the definition of a consumer for the time being. And then you're seeing other similar bills and legislation being brought up in other states that have various variations on that. So maybe employees are excluded, or maybe there's more private rights of action. Maybe the definition of personal information is slightly more narrow and realistic. So I think, as the space evolves, what's unfortunate about the U.S., and maybe it mirrors what was going on in Europe, 15, 20 years ago, with sort of a very split and fractured nature of privacy law, is that we have a few federal level laws such as HIPAA, and then we're looking at potentially 50 different variations of privacy laws that have various quirks and issues. And so, as an attorney facing that scope, it's exciting on one hand and daunting on the other. And someone in like Jeff's position is going to have to try to navigate all of those as his company is, selling global products globally, but also in every state within the United States. So I think
that's a. Oh, sorry.
Go ahead,
oh no, I was going to say. Yeah, I was just going to say. I think that's a really great point. That this is the tip of the iceberg. There have already been similar privacy laws that recently passed in Nevada and Maine, and there are, at last count, and mind you, it changes almost every week, at last count, 10 other states that were considering GDPR-like or CCPA-like legislation. So I think that's a really great point that the California Consumer Privacy Act is really just the beginning.
And I think on a national level, in theory, there could be an appetite for a national law. But folks out of California don't want to weaken the protections that CCPA has brought in, and so trying to navigate that at a national level, I think, is going to be particularly trying and difficult.
And I'll jump in just to add one point to Shannon's comment on a 30-day cure period and how fast that is, especially at a large organization. For those that work for them, for those that work with them, sometimes I can't get a new pack of pens in 30 days. So to get anything accomplished at a large international company is complex, and it stresses the importance of doing everything proactively, of planning proactively, of meeting with our privacy teams, not just internationally, but within the United States, to say, what do we need to do across the spectrum to make sure we've planned up front, because if we try to do any of this reactively, there's no way we'll get it done in time.
That's a great point, thanks. And Jeff, while we have you, do you want to discuss the regulation aspects in Europe?
Yeah. So I was fortunate enough that I moved over to Switzerland right before GDPR became official in the EU. And for those of you who don't know, Switzerland's not a part of the EU. And it brought up a really important point, which is how important it is to find the right people in the right jurisdiction who give you the right advice. There's a lot of similarities between GDPR and Swiss data privacy, but there are differences as well. So if you apply GDPR within Switzerland, you could violate Swiss data privacy. And I guess for anyone who wants to look up the laws, the important Swiss laws are 162, 271, covers sovereignty, and then 273 is confidentiality and secrecy. And some of the really fascinating points about Switzerland in particular are, the first thing is that you can't do fact-finding within the country. Fact-finding is seen as a government-specific activity. It's meant to be done by the Swiss government, not by external parties. So we can't have our attorneys do fact-finding of our custodians within the country, which presents us with challenges. And a misconception has always been that we can't have US attorneys come to Switzerland and do the fact finding, but that's not accurate. We can't have our Swiss attorneys do it either with our Swiss custodians. We can do it outside of the country. And even if we go outside of the countries, there are still personal identifiable information protections that are afforded to the custodians with the information they tell us. That's really important. Similarly, we have similar restrictions on the transfer of data. When we have a lawsuit in the United States, being a company who's headquartered in Switzerland, we're often going to have custodians who are Swiss-based and their data lives in Switzerland. And as we've touched on already, we can't just ship the data here. And sometimes our judges don't know that. We've had judges who have said, why don't you put someone on a plane, get a hard drive, and bring it back? And we can't do that. We're going to violate Swiss data privacy law, but it's also Swiss penal law. And this is one thing that adds an extra layer of consideration when you're putting a policy in place. As Shannon touched on, there's a 4% fine under GDPR of global revenue. I think we're around $50 billion. So I guess that puts us at, we're at risk of $2 billion per violation. For me, of more importance is under Swiss penal law, there's a criminal component as well. So you can be held criminally liable for violating the laws, and you can go to jail. And it's anyone who's involved. So it's me having made the decision. It's the person who puts the data on a hard drive and carries it outside of Switzerland. So again, it brings up how important it is to know what jurisdiction you're in, where the data is at, and how you can move it. And again, as a large company, 150 countries, we have to have those discussions on a regular basis. We have thousands of people who are on legal hold. We have thousands of people who we've had to collect data in. And when it's in a jurisdiction that we're not used to doing it, we don't apply GDPR standards. We don't apply Swiss standards. We don't apply CCPA standards. We go to local counsel. We go to local privacy team and say, here's our situation. What do we need to do within this jurisdiction to make sure that we're compliant? Is consent enough? What do we need to do on top of that? And then another important point that I was glad to hear brought up is the definition of personal data. In the US, we have, I would say, a fairly narrow approach. We take out or we'll redact out home phone numbers and home addresses and social security numbers and credit card numbers, date of births, things like that. Outside of the US, it's so much broader. We need to take out so much more information if we're going to go the anonymization redaction route, and it can be very complex and costly. So to make sure, again, that we are planning proactively saves us from the rush timelines, the exceeded costs, the exceeded budgets, and put us in a better position to achieve our goals.
Great, thanks very much for that perspective. And now, Rishi, would you mind talking about data regulation in Japan and Brazil?
Yeah, absolutely. And actually, before I take a deeper dive on that, I did want to address one of the things that Jeff just brought up, which is the importance of consulting with local counsel. I can't even count. It's happened so many times where we have worked with counsel, we have a plan, it looks like it will work from a GDPR perspective, but we're working in a jurisdiction in Europe where there's slightly nuanced rules that sit on top of or alongside GDPR. And those rules have to be taken into consideration. And there have been a few times where we had recommended to our clients, hey, you should check. You've spoken to your privacy officer, your privacy officer believes you're complying with GDPR, that's great, but you're also collecting data in a country that has its own specific regulations. And you need to make sure that you're speaking to somebody who understands the implications of those regulations and what they mean. And sometimes they can be related to data privacy, but they could be other data protection types of regulations. You might have to get the consent of the CEO of the local entity that sits within the country, and you can't get that consent from the parent company, for example, for a multinational company. So there are lots of nuances, and one of the ways sometimes we find our clients about to get tripped up is by not having that second consultation. They look at it purely from a GDPR perspective, and they're not thinking about those other regulations that sit alongside GDPR. And we're working with a client right now who went through that exercise and found out about a local regulation that was incredibly important and could have had significant implications for the work we were going to do. And it's a good thing they had actually gone through that consultation process, because if they hadn't, it could have invalidated basically everything we were going to do. So it's a really important point, Jeff, and I'm glad that you brought it up. So I'll touch briefly upon two other countries and two other regulations. I'm actually at a conference this week with a bunch of EY professionals from around the globe, and what's interesting is listening to their perspectives on data privacy and the different challenges that they're facing and how things are shifting. And I think Matt in his introduction had brought up this shift, this public awareness, the importance of privacy, these news headlines that Ben had mentioned in the introduction. They're all super key, and they have led to this shift. So we're seeing regulations in a number of different countries that are coming out. Most of these regulations are using GDPR as a baseline, as a starting point. Some countries had regulations before, others are implementing new regulations. But in general, that's by and large what we're seeing. I wanted to talk about Japan and Brazil specifically. I think they're quite interesting. So Japan's always had data protection rules. They have a rule, it's the Act on the Protection of Personal Information. It went into effect in May 2017, but they have a process in place to review the law every 3 years. And one of the things that was interesting when they put the law into effect was they acknowledged that data is changing so much over time. They need to be very fluid in how they interpret these rules and making sure that these rules can change. I think one of the things that was interesting about GDPR is the gap between GDPR and the directives that ultimately were in place in the 90s, and how those rules weren't really working effectively to manage how we approach data in the modern era with big data and the use of data and analytics to make strategic business decisions. So in Japan, they have a process where they're going to review it every 3 years. So while most of what I'm talking about is applicable now, by 2020, interestingly, when Japan hosts the World Cup, the Olympics, they'll have a set of new rules that will be in place. But one of the things that's interesting about Japan is they have an adequacy agreement in place, so data can move between Japan and the EU. But they don't have, and most of their rules are very similar. They have right to be forgotten, subject matter access rights, a breach notification, but they don't have the same types of penalties that some of these other rules have. So there's the upper limit currently to the penalties, $3,000 to $5,000 US, which is much smaller than the numbers that Jeff was talking about that potentially impact Novartis. And it's interesting though that despite the fact that these penalties are relatively low, and there is a potential for a prison sentence as well, though I don't think there's ever been an example of anyone in Japan going to prison because they made a mistake and breached data privacy. But what's interesting is, despite this, and maybe it's a reflection of Japan as a culture, they're very much rule followers. They are following the rule. They're making sure that things are working appropriately. And we very often are working with clients who want us to go through the process of getting consent, and where we don't have consent, redacting as much personal information as possible prior to data transfer. And that costs them a lot more money. It actually costs them way more than $3,000 to $5,000, but they really want to take a very cautious and conservative approach to it. And that will change. I think one of the things that will happen in the review that's going to take place and the new rule that will come out is that we expect to see an increase in those fines. So they're going to be similar or more similar to GDPR and CCPA. And to touch on Brazil really quickly, they have a new regulation that's coming out in 2020. Its name is Portuguese, so I'll try not to pronounce it because I'll butcher any Portuguese, but I'll use an acronym, which is LGPD. And so this rule is going to take effect in 2020. It's very similar to GDPR. It does have pretty significant fines. It's a $12 million penalty or 2% of annual revenues. Lots of similarities. They are looking at data processors, though, through a slightly different lens, and all the rules that apply to data controllers under this rule will apply to data processors, and it applies to all companies. So I know with CCPA and with GDPR, there are exceptions for small companies. In Brazil, there are no exceptions. It's going to apply to every company. Every company has to make sure that they are meeting the obligations and they're following everything they need to follow. And there are some other nuances, but in the interest of time, we'll just move on. But it's an interesting regulation. It will come into effect in 2020, and we see this being repeated in other countries within South America. So South America is about to go through an exercise very similar to the exercise the EU went through with respect to GDPR.
Great, thank you very much. I should also mention for anyone listening that you're welcome to submit questions through the online portal, and I'll be monitoring those. We're also going to run briefly now just through kind of a case exercise. And the scenario is getting data from the EU to the US for litigation purposes. Just kind of wanted to walk through this scenario from the different perspectives we have here. Matt, I don't know if you want to kick us off.
Sure, and I'll start, sort of echoing something that Jeff mentioned, that, judges in the United States maybe aren't aware or not particularly excited about the fact that regulations such as GDPR or the Swiss statutes may limit discovery within the United States or parties' ability to access data. And that stems from a Supreme Court case that's, 30-some years old, Era Postale, establishing what's supposed to be a balancing test, but as far as I'm aware, like 99 out of every 100 cases that bring it up end up with the decision that foreign data would be subject to US-based discovery rules in the first instance, and you wouldn't have to go through something like the Hague Convention in order to acquire that data. So if you're dealing with litigation that involves multinational companies with a presence in Europe as a starting point, that are within the EU, you have several hoops that you have to jump through in order to figure out what's going on. I think Jeff mentioned it as well, and others. The focus on being proactive and understanding what may exist in what problems this may bring is critical to trying to come up with a strategy and going forward. But starting. Ultimately, there's the two steps of analysis you have to do. First, you have to figure out if you have a lawful basis for processing the information in the first place. Ultimately, this becomes a compelling legitimate interest that the company has an interest in, meeting its discovery obligations and not being held in contempt within the U.S. court. But that does require a balancing act, a test against the data subject's rights and interests, and trying to take steps to make sure that protections are in place to preserve those rights and protect the data itself. So that's the first analysis that you have to do, and it has to be a documented process. The second analysis you have to do is you have to figure out what mechanism are you going to use in order to bring the data into the United States. Depending on who you ask, you could hear that there are no valid reasons for bringing it into the United States for the purposes of US-based litigation. Others may say that it's, to establish a legal claim or defense. Others may rely on consent or, potentially a last resort, a recital that sort of reads as a commentary that allows, a truly last resort for this purpose. It's a difficult sort of thing to navigate, and it ultimately ends up being risk mitigation and trying to minimize the amount of data that is being brought in, minimize the amount of personal information that is being brought into the U.S. for the purposes of litigation. And as Rishi mentioned, this means there's additional costs because you're dealing with processing and hosting and review in a foreign country where costs are much higher, and you may be dealing with a broader scope of redactions or other sort of limitations that will continue to bring cost up. So it's a difficult proposition, and I'm sure Jeff can expound on more on how they navigate that and answer sort of the risk balance test.
Yeah, I'd be happy to. When I think about Recent investigation, and I'll be quick because I see we're running short of time. We're going to have data in several countries, and it's important for us to know that early so that we can plan accordingly. So I'll just run through what we're going to do in Switzerland, and we're going to collect the data in country. We're going to store the data in country. We're going to review and redact the data in country, and I'll explain why, because we could move the data to a comparable data privacy jurisdiction and a cheaper jurisdiction. For instance, like the UK. The UK has a lot of very talented e-discovery professionals, and I would consider it to really be a front runner in the European market. Lower cost resources, and really high quality work product. We review the data in country because of what we had spoke on earlier, and it's the nuances between personal data. And it's our opinion to date that to do an accurate job of getting Swiss personal data redacted, we want to use Swiss trained attorneys because they're going to know it better than other people. And we're not going to sacrifice the quality because of costs, not with something so as important as this. Similarly, in Switzerland, we have, I guess, an additional requirement, this third-party business secrets that also need to be redacted. We run a similar risk if we produce third-party business secrets, which is often in every single contract we have with our third parties, which we're regularly going to come across in litigation and investigations. So for us, knowing how important this is, and I believe it was Rishi who brought it up earlier, it's not just a cost analysis for us. We could violate certain rules and do it cheaper. That's not what we're interested in. We want to do the best job. We want to do the most accurate job. And as important, we want to comply with the rules and laws within each jurisdiction. And anytime we don't, it's not because we did a cost benefit analysis, it's because we made a mistake. I wanted to touch on two more things that Matt had said and that Rishi said. Matt had mentioned a Hague request. We just had a Hague request from an opposing side on a party, and we successfully were able to win that request, and I guess get the request denied to turn over data because their ask was so broad and cumbersome. And knowing the amount of time and work that goes into these cross-border data transfers, you need to be very specific if you're going to use a Hague request to get data in Switzerland. And the last thing I wanted to note, because I learned it today from Rishi as far as Japan going back and reviewing their policies and data privacy laws every 3 years. Internally, I think as a corporation, as a law firm, today you need to do it even more frequently. What we've set up in a certain country, even 1 year ago, might not be good enough today. And it's important that you go back and evaluate what you've set up across the globe, because as we've all touched on, things are changing so quickly. And now in the US that we're having a change on a monthly basis, you can see how important it is to address it quickly and to be on the forefront of these activities, because the fines are one thing, but the reputational harm to a corporation is and a lot of times more significant.
And add to what Jeff just said, we're seeing some of the mechanisms for transfer constantly being challenged. So in the EU, you can use the Privacy Shield today, but Schrems, who helped bring down Safe Harbor a few years ago, he's going after it really aggressively. Standard contract clauses are another mechanism that can be used, but they're also in his crosshairs. So right now you could have these mechanisms, you could think they're valid, but they could be gone within the next 6 months or so. So to Jeff's point, you have to constantly evaluate and look at it. And it's not just looking at the regulation, but it's looking at the court's interpretation of those regulations and what's acceptable and what's not. And the European Court of Justice could very easily get rid of a lot of these processes by which we move data from the EU to the US.
And I'll just add one piece real quick. And when I say look at it, I mean ask the right people, because as I mentioned, even spending a couple years in Switzerland, I still don't know the laws as well as our Swiss litigators do, our Swiss attorneys, our data privacy attorneys. It's reaching out to people like Rishi, Matt, and Shannon who clearly know what requirements are, what you can do, what you can't do, as opposed to reading a few things on yourself. The risk is too great to not seek expert advice on topics like this.
Thank you all. We're going to move to a couple of quick questions that have come in. One is, how did the new GDPR regulations impact public institutions of higher education? And anyone who wants can field this.
So I could take that one. This is Shannon. So as I was discussing earlier, the extraterritorial application of the GDPR is a good place to start. And I know a number of US-based organizations take the view that the GDPR did not apply because they were only operating within the US. For organizations that have a concerted effort to recruit students from the EU, they may have to reconsider whether the GDPR applies or not, particularly in light of the European Data Protection Board's guide to the extraterritorial application of the GDPR that came out in January of this year.
Thanks. Anyone else on that? Okay, another question we have is, are you aware of any suggestions or resources interpreting the HIPAA exceptions under the CCPA?
That's a fantastic question. I'm not aware specifically of any commentary that's come out on that yet. It's a really interesting carve out because it doesn't apply to organizations that are covered by HIPAA, so covered entities. It actually just applies to information that's covered by HIPAA. So by way of example, you could have a covered entity that's subject to HIPAA and it processes certain information that's not covered by HIPAA. So for example, it's employee data or data that it uses in a marketing context. It may be that the AG regulations that come out hopefully this autumn will provide additional color around the HIPAA and CMIA exemptions. So I think it's really important to watch what the AG says.
Great, thank you. And then based on the theme of the panel, I'm just going to throw this question out to all of you. Does anyone have any advice in particular for young or early career lawyers with respect to practicing in this area of law?
I'll jump in on this. I'm also a law school professor, have been for 5 years, and this is an area in law where I'm frequently trying to get my students to take up an interest. It's an area that's growing. As I tell them, if you start out a prosecutor like myself, that field's not growing. If anything, hopefully crime's getting a little bit better. But in one area it's not growing, so the jobs aren't booming. In the other area, your learning curve is so much longer. If I was still a prosecutor a decade plus later, I'd start to be a senior prosecutor at this point. In these other areas that are newer and fast changing, you can jump in now, and 3 and 4 and 6 years later, you can really become an expert in your field and advance through your career so much quicker than you are in other areas. So I think for young attorneys, a booming space that I find very interesting and that has so many interesting components and links to technology and international laws that I couldn't encourage someone to get into it more.
Yeah, you go ahead, Shannon, sorry.
Oh, right. I think I would echo that as well from a privacy practitioner standpoint. I'm going to mention 4 things. Like I think was mentioned, it's a really growing area. There's so many opportunities here. People in privacy are genuinely interested in privacy. I go on privacy hikes on the weekend, which is super nerdy, but I have a bunch of people who are involved in privacy. We hang out and talk about privacy. So it's an area of law that it's fascinating and it's growing. And there were 2 other things I think I would mention. In terms of a career, it's the hours are more predictable than in litigation or corporate. So I think that's worthwhile considering just from a work-life perspective. I know that in litigation, coming up to trial, people can work really around the clock. And same with respect to corporate in the context of deals. And privacy, you have a slightly more control over your hours in a more regulatory practice.
And just to add to that, because privacy is so interlinked with data, and data right now is being used in so many different ways by businesses to make strategic decisions, by politicians and political parties to decide who they might target from a canvassing perspective. It's one of the fastest growing areas of law. Being at this conference and meeting my international colleagues, there isn't a country that's not thinking about how to approach this, how to think about it. And it dovetails nicely into cybersecurity, which is one of those other areas that's growing rapidly, and the need to have a breach response and a need to think about cybersecurity through the lens of privacy and where you put data and where you host data. It's an incredible opportunity for any young professional who begins their career, whether they're a lawyer or whether they're a technologist or whether they are a business leader. It's so important for everyone to consider. So it's really an exciting time to be involved in it.
The last thing I'll add on this. Sorry, go ahead, Ben.
I was just about to turn it to you.
Okay. The thing I would add is it applies to basically every type of practice of law that you will be involved in. Litigation, corporate, public interest, all sort of intersect with this sort of concept. And because it's such a young field, particularly in the U.S., it is a great opportunity for young lawyers to establish their expertise and get a seat at a table that they maybe otherwise wouldn't get. And I think that can really help advance people's careers and put them in a position where they're contributing in a substantive way earlier in their career than they maybe would have.
Great. So I hope you've all gotten a sense of the scope and significance of these topics and a taste for how much work there is to be done and the great associated opportunities. I'd like to extend a hearty thank you to our panelists for the generosity of their time, and also to our co-sponsors. This session will be accessible as a recording through the ABA website to members going forward. And just a reminder that the ABA Wildys Litigation Week continues tomorrow. Our last session is on the future of Roe v. Wade. Thank you all for attending this webinar, and have a great day.